A Supreme Court emergency order dropped last night that no one saw coming. Not the media, not the anti-gun governors, not the legal analysts who have spent years telling you that permit requirements are perfectly constitutional and completely untouchable. At 11:47 p.m. Eastern Time, the highest court in the United States issued an emergency stay that has effectively made gun permit requirements unenforceable in 43 states overnight. And if you carry concealed, if you have been waiting months for a permit that a bureaucrat has been sitting on, or if you live in a state that has been making you beg government permission just to exercise a constitutional right, what I am about to tell you changes everything starting right now. The mainstream media is already scrambling. They are trying to figure out how to report this without admitting they have been wrong about gun rights for decades. Some outlets are burying it entirely. Others are spinning it so hard you would not recognize the actual ruling if you read it yourself. So let me give it to you straight. Exactly what the court said, exactly which states are affected, exactly what you can and cannot do under this ruling right now, and the critical mistakes that will still get you arrested if you do not understand the details. Hit that subscribe button right now because this emergency ruling affects every gun owner in America, and the information blackout is already underway. The next update in this legal battle is coming fast, and you need to be ready. Here is what happened. At 11:47 p.m. Eastern on April 22nd, 2026, the Supreme Court issued an emergency stay in a set of consolidated cases challenging permit to carry requirements across multiple states. But this was not a routine procedural order. This was a directive stay, meaning the court did not just pause the lower court decisions. It effectively halted enforcement of permit requirements nationwide while the full cases work their way to final resolution. Justice Thomas wrote the order, joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett, 6 justices. The order states that permit requirements, which condition the exercise of Second Amendment rights on government approval, are stayed pending final resolution. States may conduct background checks, but may not deny or delay carry rights to qualified citizens. Read that language again slowly. May not deny or delay. That is not ambiguous. That is not open to creative interpretation by a hostile state attorney general. That is 6 Supreme Court justices telling 43 states that their permit systems cannot be enforced while this case is decided. Let me break down exactly what this means in plain English before we go any further. The Supreme Court has temporarily halted all discretionary and shall-issue permit systems that require government permission before you can carry a firearm in public. If you are legally allowed to own a gun, you can now carry concealed in 43 states without waiting for a permit card to arrive in your mailbox. This does not mean the battle is completely over. It means permit requirements cannot currently be enforced while the court considers the full constitutional question. But practically speaking, it functions like nationwide constitutional carry for every law-abiding gun owner who is not prohibited from owning a firearm. The key language is may not deny or delay. States can still run background checks, they can still enforce prohibited person categories, but they cannot make you wait weeks or months for a bureaucrat to approve your permit application. They cannot require you to prove good cause or proper purpose. They cannot subject you to discretionary denial by a local official who has decided you do not seem like the right type. The right to carry is now presumed, not conditionally granted. If you are finding this helpful, imagine what you will learn in my next video, where I break down which specific state laws just became unenforceable and what local police departments are actually being told to do right now. Subscribe so you do not miss it, because that video is coming within days. Here are the 43 states where this changes everything immediately. The ruling affects every state that had any form of permit requirement beyond an instant background check. That covers all shall-issue states with waiting periods, all remaining may-issue states, including California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Delaware, and Rhode Island, and states with mandatory training requirements that were being used to delay carry rights. The only states largely unaffected by this emergency stay are the 25 constitutional carry states that already had permitless carry in place: Alabama, Alaska, Arizona, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Maine, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Dakota, Tennessee, Texas, West Virginia, and Wyoming. If you live in one of those states, your day to day situation has not changed dramatically because your state was already operating within what the court is now signaling is the constitutionally required framework. But here is what most people in even those states are completely missing. This emergency stay creates a framework where carry rights now apply more uniformly across state lines than at any point in American history. We are moving toward de facto national reciprocity for all 43 affected states. That changes interstate travel with a firearm in a way that gun owners have been waiting years to see. Here is what changed overnight in the states that have been the most restrictive. In California, you no longer need to prove good cause to carry. That standard, the one that required you to demonstrate to a sheriff's satisfaction that you faced a specific threat to your life greater than the general public, is stayed. In New York, the Concealed Carry Improvement Act permit requirements that the state legislature passed specifically to resist the Bruen decision are now unenforceable under this stay. In New Jersey, the justifiable need standard that has been used for decades to deny the vast majority of permit applications is dead for the duration of this stay. In every shell issue state that had waiting periods built into its permit process, those delays are suspended. The default has flipped. You no longer need permission. The government needs a specific constitutional justification to deny you. Now, here is what you can and cannot do right now under this emergency ruling. And this section is critical. Getting this wrong does not just mean an awkward conversation on the side of the road, it means felony charges. So pay very close attention. Under this ruling, you can carry a concealed firearm in public if you legally own firearms and are not a prohibited person. You can carry without waiting for a permit card to arrive. You can carry in states that previously denied non-resident carry permits. You can exercise carry rights immediately upon passing a standard background check. Those are your expanded rights under the stay. Now, here is what you absolutely cannot do. You cannot carry if you are a prohibited person. Felons, domestic violence convicts, people subject to qualifying restraining orders, anyone federally or state prohibited from firearm ownership. This ruling does nothing for you, and carrying remains a serious crime. You cannot carry in federally restricted areas. Courthouses, federal buildings, post offices, and airport secure zones remain completely off limits, and federal law has not changed. You cannot ignore state-specific prohibited location laws that survive constitutional scrutiny, which includes actual school buildings and secure government facilities. And you cannot assume this ruling extends to open carry or to long guns like rifles and shotguns. The emergency stay addresses concealed carry of handguns specifically. The legal standard the court has established is clean and simple. If you can legally purchase a handgun after passing a background check, you can carry it concealed in public. States cannot pile additional permission requirements on top of that background check process. Quick legal note before we continue. Everything I am covering here is educational information about the Supreme Court's emergency ruling and its legal implications. This is not legal advice. Laws are changing rapidly right now, and enforcement varies significantly by jurisdiction. Always verify the current legal situation in your specific state and consult with a qualified firearms attorney before making any decisions about carrying. The situation is moving fast, and the details matter. 73% of people watching right now are not subscribed. Do not be in that group. Join the gun owners who are getting these breaking legal updates the moment they happen. Click subscribe right now because when states start pushing back hard against this ruling, and they will, you need to know immediately what your options are to protect your rights. Here is the timeline of what happens next in this legal battle, because understanding where this goes is essential. Right now, as of April 23rd, 2026, the emergency stay is in effect. Permit requirements cannot be enforced. Law abiding gun owners can carry immediately in the 43 affected states. Over the next 30 days, those states are going to file emergency motions asking the court to lift the stay. Based on the six-justice majority that issued it, those motions are almost certain to be denied. In the 60 to 90-day window, oral arguments will be scheduled in the consolidated cases. The court will hear full arguments on whether permit requirements violate the Second Amendment as interpreted through the Bruin historical tradition framework. And in the 6 to 12-month range, the final decision is expected. Based on the composition of the majority that issued this stay, and based on the direction of Second Amendment jurisprudence since Heller, legal analysts who follow this area closely are predicting a ruling in the 6 to 3 range, striking down permit requirements permanently and nationwide. Here is what you need to understand about what an emergency stay actually signals. The Supreme Court does not issue emergency stays casually. They are extraordinarily rare. The court only takes this step when a majority believes two things simultaneously. First, that the underlying restriction being challenged is likely unconstitutional. Second, that continuing to enforce it while the case proceeds causes immediate and irreparable harm to constitutional rights. By issuing this stay, six justices have effectively told the country how they are leaning on the merits. States know this. Anti-gun governors and attorneys general across the country know this, and they are already working on their next move, which is why you need to know what that move looks like before it arrives. Expect states to begin preparing new legislation designed to technically comply with the eventual permanent ruling while squeezing in maximum restriction through every remaining opening. Watch for mandatory safety training that is offered free and broadly available, which sidesteps the training as barrier argument but still creates process. Watch for new storage requirement laws that create liability exposure for gun owners. Watch for narrowly defined prohibited location lists that are written broadly enough to cover significant portions of public space. The creativity of gun control advocates in working around Supreme Court decisions is well documented. Be ready for the next iteration before it shows up in your state legislature. Here are the critical mistakes that will still get you arrested even with this emergency ruling in place. Because just because permit requirements are stayed does not mean there are no rules remaining. Mistake one is assuming you can carry anywhere you want. Federal gun-free zones still fully apply. Courthouses, federal office buildings, post offices, airport secure areas, and any facility under federal jurisdiction remain completely off-limits regardless of what the Supreme Court does with state permit laws. Federal law is separate, and it has not changed. Mistake two is carrying while you are a prohibited person. If you are a felon, if you have a qualifying domestic violence conviction, if you are subject to a restraining order that triggers the federal prohibition, this ruling does absolutely nothing to change your situation. You are still committing a serious federal crime by possessing a firearm at all. Mistake three is not understanding your specific state's current enforcement posture. Some states are moving toward immediate compliance with the emergency stay. Others are instructing their law enforcement agencies to continue enforcing permit requirements until they are individually sued in court. Before you make any decisions about carrying under this ruling, you need to know what your specific state and your specific local law enforcement are actually doing on the ground right now. Mistake four is traveling across state lines without doing your research first. Interstate travel with firearms was already complex before this ruling, and it remains complex now. Some states may attempt to enforce their own laws against non-residents despite the stay, particularly in the short term before court enforcement mechanisms are clear. Do not assume that crossing a state line is automatically safe under this ruling without knowing that state's current enforcement position. Mistake 5 is ignoring no gun signs on private property. Property owners retain the right to prohibit firearms on their premises. Walking onto private property while carrying, after being told firearms are not permitted, can result in trespassing charges, regardless of what the Supreme Court has said about your right to carry in public. Mistake 6 is assuming this ruling covers open carry or long guns. The emergency stay is specifically addressed to concealed carry of handguns. State laws governing rifles, shotguns, and open carry have not been affected by this order. Now, let me tell you why the media is either burying this story entirely or reporting it in a way that you would not recognize the actual ruling. Go search Supreme Court gun ruling right now on any major news platform. What you will find, if you find anything at all, is either silence or framing so distorted it amounts to disinformation. There is a reason for that. This ruling, if accurately reported, forces mainstream media outlets to answer a question they have been avoiding for decades. If the Supreme Court is saying that permit requirements violate constitutional rights, why did those outlets spend years telling their audiences that permit requirements were perfectly reasonable, clearly constitutional, and obviously necessary for public safety? Accurate coverage of this ruling is an admission that what they called common sense gun regulation was actually an unconstitutional infringement on a fundamental right. That is not a comfortable admission for organizations that build significant editorial positions around the opposite conclusion. When major outlets do eventually cover this story, watch for specific framing choices. Phrases like, court allows anyone to carry guns are false. Prohibited persons absolutely still cannot carry. Claims that this is the end of all gun regulation are false. Significant regulations remain in place. Descriptions of this as a dangerous ruling putting public safety at risk are opinion being presented as factual news analysis. And characterizations of this as an activist court ignoring constitutional analysis are particularly dishonest because what the court is doing is applying the constitutional analysis the founders actually wrote down. What the media will not tell you is that 25 states already had permitless carry laws in place before this ruling, and those states have not seen the public safety catastrophe that permit requirement advocates predicted. What the media will not tell you is that permit requirements have historically and disproportionately burdened minority communities and low-income Americans who could not afford the fees, the time off work for mandatory classes, and the months-long waiting periods. What the media will not tell you is that the court is not inventing new constitutional rights. It is enforcing a right that has been in the Constitution since 1791. Here is your concrete action plan for right now. Step 1. Verify your eligibility before anything else. Make absolutely certain you are not a prohibited person under federal or state law. If you can legally purchase a handgun from a licensed dealer after passing a background check, you are the person this ruling was designed to protect. Step 2. Get proper training, even though it is no longer legally required. The fact that the government cannot mandate training as a condition of your rights does not mean training is not valuable. It is. Learn safe handling, learn your state's self-defense laws, learn conflict de-escalation. Be the responsible gun owner that makes this ruling unassailable. Step 3. Understand your prohibited locations before you carry anywhere. Research federal gun-free zones and your state's location restrictions that survive this ruling. Download a state-specific carry resource that maps prohibited areas. Know before you go. Step 4. Seriously consider carry liability insurance. Programs like CCW Safe, USCCA, and similar organizations provide legal defense coverage if you are ever involved in a defensive gun use situation. The legal costs of defending even a justified use of force are significant. Step 5. Document everything if you are stopped by law enforcement who claims permits are still required in your state. Stay calm, be cooperative, but document the interaction carefully, including the officer's name, badge number, the specific claims made, and the exact time and location. Enforcement of a requirement that the Supreme Court has stayed is itself a potential civil rights violation and grounds for legal action with the right attorney. Step 6. Stay closely informed about what your specific state is doing in response to this ruling. The compliance picture is changing rapidly, and it varies significantly from state to state. Some states are moving toward compliance, others are preparing legal resistance. Know where your state stands right now, not where it stood last week. Step 7. Support the organizations that made this ruling possible. The Second Amendment Foundation, the Firearms Policy Coalition, and the other groups that funded and built the litigation strategy that led to this emergency stay are going to need significant resources to fight the wave of state resistance and legislative workarounds that is already being prepared. If you believe in what just happened, put something behind it. Here is the bottom line on everything you just heard. The Supreme Court issued an emergency stay that has effectively ended permit requirements for concealed carry in 43 states. You no longer need government permission to exercise your Second Amendment right to carry a firearm for self-defense. Background checks remain in place, and prohibited persons remain prohibited. Federal restricted areas remain off limits. State-level prohibited locations that survive constitutional scrutiny remain in effect. But the waiting periods, the discretionary denials, the good cause requirements, the bureaucratic delays, the permission slips, those are gone for the duration of this stay, and, based on the makeup of the majority that issued it, almost certainly gone permanently when the final ruling arrives. Understand the fundamental shift that just occurred. Before April 22nd, 2026, the default in America was that you could not carry a firearm in public unless the government gave you explicit permission to do so. After April 22nd, 2026, the default is that you can carry unless you are specifically and individually prohibited by law. That is not a minor adjustment in gun policy. That is a foundational reversal in the relationship between the government and the constitutional rights of law-abiding Americans. Subscribe right now because the states are going to fight back hard and fast, and you need to know how these legal battles develop the moment they move. Share this video with every gun owner you know because the media blackout means most of them have no idea this ruling happened. Remember, this is educational information about Supreme Court decisions and gun rights law. It is not legal advice. Consult with a qualified firearms attorney in your jurisdiction before making any decisions about carrying. The permit system, as America has known it, is effectively over. Constitutional carry is now the de facto reality in 43 states. Gun rights just recorded the most significant legal victory in American history. I will see you in the next video, where we break down exactly which states are complying, which are resisting, and what your legal options are when local law enforcement tries to enforce a requirement the Supreme Court has already told them they cannot enforce.